Mark November 24th, 2025 on your calendar. Something happened that has never occurred in the entire history of the United States. The Department of Justice filed a brief supporting the Second Amendment. Yes, you heard that right. For the first time ever, DOJ is actually defending gun rights before the Supreme Court in Woolford v. Lopez. Before I break down what this means, hit that subscribe button, because what I'm about to show you will change everything you thought you knew about this administration. The bipolar department. Why this feels so confusing? Here's what makes this so complicated. The Department of Justice recently doubled down on NFA regulations in the silencer shop case, and frankly, a lot of us were furious. I was furious. And every single time we're about ready to write off Attorney General Bondi completely, assuming you haven't already, something like this happens. So here's what happened on a call I had today. There were several people on the line, all of us trying to figure out the same thing. Do we support this DOJ or not? And then this attorney speaks up and says something that stopped everyone cold. He said, "Why does this have to be all or nothing? Why can't we just be honest about what's in front of us?" Here's his point. If you want credibility, if you want people to actually trust your analysis, maybe you should just call it like you see it. This DOJ has done things that have never been done before. Good things. Historic things. But the healthiest thing we can do is stop treating this like a loyalty test and start evaluating each action on its own merits. But here's what most people don't understand about why this case even exists in the first place. Hawaii's response to BRUEN, the law that started it all. The Department of Justice points out something critical in their brief. Hawaii enacted a series of laws in direct response to what the Supreme Court ruled in BRUEN. Now, if you remember, BRUEN invalidated Hawaii's prior firearm licensing regime, under which Hawaiians could virtually never obtain public carry licenses. The data was staggering. Between 2000 and 2022, Hawaii issued fewer than 4 carry permits per year statewide. So what did Hawaii do after BRUEN forced them to loosen restrictions? Hawaii responded by technically loosening its licensing requirements, but then simultaneously enacted a new restriction that effectively nullifies those licenses and prevents public carry anyway. It's like telling someone they can have a driver's license, but then banning them from every single road. And here's where it gets even more absurd. The new law doesn't just restrict certain sensitive places like courthouses or schools, places where restrictions have historical precedent. Instead, it created a blanket presumption that covers virtually everywhere in the state. According to property records, approximately 94% of land in Hawaii, where people conduct daily business, falls under this restriction. But wait until you hear how this law actually works in practice. The Vampire Law, how Hawaii flipped everything backwards. Now, I want you to understand what the problem is with Hawaii's vampire law here. In any other normal state, if private property owners want to exclude firearms from their property, all they need to do is post a no-gun sign. The way it works in Hawaii, however, is completely backwards. You're supposed to presume that any place that is privately owned yet held open to the public, and that's just about anywhere you could possibly think about in Hawaii, is automatically a no-gun zone. And only if a property owner posts signage that directly consents to firearms may you actually carry on to that property. And you sit there and you go, how on earth did the Ninth Circuit uphold this? Well, first of all, it's the Ninth Circuit. But their reasoning gets even more absurd when you look at what they use to justify it. The historical fiction, 6 laws that don't prove anything. When it came to trying to justify this law through historical analogs, the Ninth Circuit got incredibly creative. So much so that the Department of Justice takes them to task in this brief. The Court of Appeals invoked 6 supposed historical analogs to support Hawaii's law. But here's the problem. 5 of those 6 laws applied only to property closed to the public, not open to the public. And then the United States Department of Justice does something remarkable. They essentially create a new standard for how relevantly similar historical laws really need to be. DOJ argues that even setting aside all the other problems, Hawaii's affirmative consent rule is unconstitutional because it is a modern-day aberration and not relevantly similar to laws that our tradition has understood to permit. In other words, you can't just grab random old laws and pretend they support what you're doing today. But there's another angle to this case that opens up an entirely different constitutional problem. The First Amendment trap, when Hawaii opened Pandora's box. Here's where Hawaii's legal strategy backfires spectacularly. The state tried to uphold this law on First Amendment grounds as well, arguing that property owners have free speech rights to control what happens on their property. It's probably a terrible strategy because it opened up a Pandora's box of arguments that now work against them. DOJ points out that the Supreme Court's First Amendment cases have established a clear principle. Government may not require a speaker to obtain a homeowner's affirmative consent before going door to door to communicate religious ideas, before mailing political literature, or even before mailing advertisements for contraceptives. The Supreme Court has repeatedly held that you cannot force people to opt in to receiving protected speech. Here's the practical effect. If you are a property owner in Hawaii, and you have no problem with people exercising their Second Amendment rights while they're on your property, you are now compelled by government to engage in speech, to post a sign in order for them to exercise that right. The government is forcing you to say something. The First Amendment guarantees you the right to say whatever you want. It also guarantees you the right to not have to say anything that you don't want to say. By creating a default ban and requiring affirmative consent signage, Hawaii is compelling speech from property owners who would otherwise remain silent. But here's what this all means when you step back and look at the bigger picture. What this really means, the historic significance. Put this in perspective. The Department of Justice hasn't just filed a brief. They've taken a position that fundamentally challenges how states have been responding to BRUEN. At least 7 other states have enacted similar sensitive places laws that create default bans with opt-in requirements. If DOJ's arguments prevail in Woolford v. Lopez, those laws are all on the chopping block. This isn't just about Hawaii. This is about whether states can effectively nullify Supreme Court decisions through legislative creativity. DOJ is arguing that states cannot evade BRUEN by banning public carry through indirect means. Is this Department of Justice completely bipolar? Yes, they are. Is your reaction to them probably going to be just as bipolar? Absolutely. And if you're being objective and calling balls and strikes, that's exactly what we're going to get with this DOJ. But let's make no mistake about it. November 24th, 2025 is a significant day because the United States Department of Justice, for the first time in American history, has filed an amicus brief in support of the Second Amendment and lawful gun owners nationwide before the United States Supreme Court. The case is Woolford v. Lopez, and oral arguments are scheduled for January. The case is Woolford v. Lopez, and the amicus brief is linked below so you can read every word DOJ wrote yourself. If this is the kind of analysis you want to see more of, where we call it honestly, without the bias, smash that like button and subscribe right now because we're tracking every move this DOJ makes. Drop a comment and tell me whether you think we should trust this Department of Justice or keep one hand on the eject button. Stay informed, stay ready, and I'll see you in the next one.